want to get some perspective right now from two attorneys who specialize in civil rights cases. We're joined live by attorneys Natalie Jackson and Howard Marks. Thanks so much for being with us. Natalie, do you think this is an issue of poor training or police union protection?
Well, you know, that's kind of a complicated question because police union protection, I've got a rethinking of police unions. Their job is to protect the employees of the police. So I think what we need to focus on is the politicians who pander to the police unions. And they're the ones that are allowing police unions to get away with so much. So I think we need to, instead of questioning police unions, go back to questioning politicians who pander to police unions. When you talk about, is this a question of poor training? No, these are criminal acts. This is not training. This is not, what we're seeing on television are criminal acts that are being sanctioned. You have what police officers who are government entities who are licensed and sanctioned to take your life and liberty, committing criminal acts on television and not being held responsible. That goes back to the people who are in charge who allow this by pandering to the police unions, which brings it all back to the elected politician.
All right, Natalie, thank you. We want to turn right now to Howard Marks. Same question for you. Do you think these are police officers protecting police officers, poor training? What are your thoughts?
Well, a lot of it has to do with training. A lot of it has to do with admitting there's a problem, addressing that there's a racial bias, and addressing the conduct of the officers that conduct excessive force, which has not changed in the last 25 years since I've done this. You have to look at the force continuum. You have to look at not only the officers liable, but you have to look at holding the departments liable. And under the Florida law, the way it is with qualified immunity, it's either one or the other, and it's just not acceptable. You cannot conduct like that because the law enforcement officer says, I was just doing what I was trained to do, and the law enforcement agency says, well, the law enforcement officer, either they were rogue or they did what we trained to do. So it is the training that's occurred. They put officers in situations where there's pretextual stops, minor offenses, tinted windows, driving while black, seatbelt offenses, and they wind up escalating to dangerous situations, not only for law enforcement, but also for citizens involved. These are not really crime investigations that they're concerned with, and these kind of activities need to cease because most of them and many of them wind up with excessive force by law enforcement officers, which is just unacceptable in our society. I mean, we have law enforcement that takes seatbelt offenses and wind up pulling people out of cars, and you have a contact between the citizens and law enforcement, which wind up, I have one right now 7 blocks from downtown Orlando, where they put the knee on the neck of an individual relating to a seatbelt offense who's begging that they can't breathe. This kind of conduct cannot continue. And quite frankly, for the last 25 years, it doesn't matter who the sheriff is. It doesn't matter who the police chief is. These activities continue. So I believe training in this area and de-escalation training in this area, conflict management in this area, and training that you do not do proactive patrols where all you're doing is looking for trouble. These have to stop because that is a great amount of the excessive forces cases that I see that coming into my office for the last 25 years.
And again, you say decades, Howard, of you in litigation over this. Clearly now is the time that we need to address this head on. Natalie Jackson, Howard Marks, thanks so much for joining us. Vanessa.